Hello everyone, my name is Luciano Oliveira. I am a Brazilian attorney, also licensed in California and Texas. And today I'm going to answer this question. Is there a statute of limitations when it comes to probates in Brazil? And the short answer is yes, there is one, but there are actually two different timelines that you need to pay attention to. The first one is going to be the 60 days that someone has to file a probate in Brazil. It's kind of rare for probates in which foreign citizens are going to be a party to be able to file in such short time. So don't feel bad if in your case your family is unable to file within the 60 days. The 60 days means that if you don't file within the timeline, there is a small increase on the taxes applicable to the probate. Yes, it's desirable to avoid additional taxes, but what I'm trying to say here is that if you lose this timeline, nothing too serious is going to happen to the probate and the assets. Now, the second timeline, this is the concerning one. That's the 10 years timeline, and this is the actual statute of limitations, meaning that if you cross the 10 years without participating in a probate, you would lose your right to the inheritance to claim a piece of the assets. And interesting enough, if there is a probate, but you don't get notice of the probate and the local parties, let's say you have siblings in Brazil, and the siblings, they don't tell you about like a parent. Let's say if you are, estranged from this parent, and then you learned like 5 years down the road that this parent passed away, you would still be able to file for a probate even though the original probate was completed. You would basically hire an attorney in Brazil, inform to the court that the local parties, they left you outside alone, they left you outside of the probate, and therefore you are filing for an additional probate in order to pursue the share of the assets that would be yours. And very interesting for you to note, because in the United States, very common, like for families when they have, some type of dispute or fights, people are going to draft wills in a way that they are going to exclude certain family members. But in Brazil, remember that there is a mandate for at least 50% of the assets to be distributed in a certain manner. So even if there is a will, for instance, in the United States, excluding you from the probate, it is possible, as long as there are Brazilian parties involved, that the judge is going to say, you know what, 50% I agree with the deceased's will, but the other 50% is going to be distributed in accordance with the Brazilian law. And in accordance with the Brazilian law, a testament, a will, is not going to allow the deceased to exclude children, for instance, unless something really, really bad happened between the child and the parent, such as the child actually tried to kill the parent. But even if there was like a physical altercation and a lot of bad blood between the child and the parent, this would actually not be enough for the court to allow the exclusion of such child. Also interesting to note, if after the 10 years nobody filed for a probate, the state may very well sell the property and send the proceeds to the state instead of a family member, because no family member has appeared in order to claim the assets. Another possibility is that because nobody is paying, for instance, for the taxes on a certain property, the property is then sent for auction, and even before the 10-year mark, the property ends up going to the state because of unpaid property taxes, for instance. I hope these tips were helpful. Consider scheduling a consultation to discuss your case, and follow us for more tips.